Yeah, so I was just saying another problem of the European Court is just the large number of cases that come before it that it has to deal with. So they've got a backlog of something like 65,000 cases or something like that that have been applied, and obviously they're never going to hear them all. Typically, vast majority of people who bring a case to the European Court, that case will never get heard. For those cases that do get heard, it usually takes 3 to 5 years from bringing the case to it actually being heard by the judges. And the final problem is that it's actually very costly to bring a case to the European Court. So those will be the limitations. Nevertheless, for those cases that do get heard, as I say, there's a 90% compliance rate with the court's judgments, indicating that it is relatively effective at upholding human rights, at least within those 47 member states that have signed up to it. Okay, let's move on to the International Court of Justice. This was created in 1945. It's another of the institutions of the United Nations. It's also known as the World Court. It's basically the UN's court. Now, its remit is relatively limited. It can't try any old human rights abuse case. It's specifically limited to dealing with problems between states, things like territorial disputes, or if a country has a shared resource, two countries have a shared resource like an oil field, if one feels that the other's siphoning off too much, or these kinds of things. So it's specifically to deal with disputes between states. Nevertheless, it can still be relevant to the issue of human rights, because as we know, things like the right to self-determination is considered one of the collective or solidarity rights under the third generation of human rights. So these things might come into play in rulings by the International Court of Justice. It's based in The Hague in the Netherlands, and it has had some successes during its existence. Particularly where it's a case of smaller states that have got a dispute with each other, and where they're both relatively similar in terms of their power. So let me give you an example. Major dispute between El Salvador and Honduras in 1969, and the ICJ was able to come up with a solution to that. Now, what happens in these cases is the case will be brought, and then both parties have to decide are they happy to submit to whatever the court rules and judges. So in this case, both countries agreed, yep, we'll abide by whatever the decision is, and indeed they did, and that ended the conflict between those two countries. Another example, this was a territorial dispute over the boundary between Cameroon and Nigeria in 2002. That was successfully resolved by the ICJ because both countries submitted to its rulings. They said we'll abide by whatever the judgment is, and they did. So they've had some successes in conflict resolution, and of course the human rights ramifications of that are one that the right to self-determination and so on of each state is not being infringed on. But secondly, of course, if you resolve a conflict, then all of the human rights abuses that inevitably happen during conflict are also limited if the conflict itself is resolved. So this has relatively had some successes in upholding human rights by resolving conflicts. However, again, the ICJ cannot enforce its judgments. As I said, it has to rely on both states just voluntarily agreeing to abide by its judgments. And there have been several well-known cases where states involved have just ignored the rulings. So famously in 1984, when the US, the CIA, was actually mining Nicaraguan harbors, Nicaragua brought the case saying this is a violation of our sovereignty and so on. The ICJ made a ruling in favor of Nicaragua, demanded the US stop, and the US just ignored the ruling. Similarly, more recently, the ICJ ruled that the wall, the so-called apartheid wall, or separation fence, between Israel and the occupied parts of the West Bank and Gaza, that was ruled by the ICJ to be illegal, the building of that wall, because it was encroaching on Palestinian territory, dividing farmland, ruining farmland, and so on. But again, Israel just ignored the ruling. And very recently, just last year, I think 2017, the ICJ ruled that China's activities in the South China Sea, building these so-called artificial islands and so on, ruled that they were illegal, and China said it's just going to carry on, it's going to ignore the ruling. So I think what these cases suggest is that whilst the ICJ can be relatively successful in dealing with conflicts and disputes between, as I say, smaller states of relatively equal power, once you have conflicts between a very powerful state on the one hand and a much less powerful one, the more powerful one, if it's ruled against, is very likely to just ignore the ruling. So the examples I gave you, Israel, the US, China, these are all relatively powerful states that were infringing on the rights of much less powerful states, like Nicaragua, or the Philippines in China's case. In Israel's case, of course, Palestine isn't even a state, so it's even less powerful than a state. So the ICJ's main limitation, I would say, is that when it's dealing with bigger states, more powerful states, it's less likely to be adhered to. Its rulings are less likely to be adhered to. This arguably another limitation of the ICJ would be that its jurisdiction is limited to states, so it can't prosecute individuals. Now that brings us to 4 what called ad hoc UN tribunals that began to be set up in the 1990s. This is where the UN Security Council created, if you like, short-term, what we mean by ad hoc is kind of short-term, temporary, to deal with a specific issue. So in the 90s and onwards, the UN Security Council created special tribunals, kind of these temporary short-term courts, to deal with 4 specific wars, conflicts, basically. So they set up a tribunal for Sierra Leone. There was a civil war there in which many atrocities had occurred. One for Yugoslavia, for trying war people guilty of or suspected guilty of war crimes in the Yugoslav civil wars. One criminal tribunal for Rwanda, and one for Cambodia. All these countries had devastating civil wars with huge numbers of atrocities and human rights abuse committed within them. So the UN Security Council created these 4 separate courts to specifically try individuals responsible for war crimes committed during those conflicts. And what was, as I say, what was new about this, and what was, I won't say revolutionary, but what was, let's say, unprecedented, was the idea that an international court would actually try an individual. Like I say, with both the European Court of Human Rights and the International Court of Justice, they actually make rulings in relation to states or governments. So there's no, in with both of those courts, there's no justice in the sense of individuals responsible being punished. Now the ad hoc UN tribunals were different because they would prosecute individuals for war crimes. And if they're found guilty, they would actually have the power to impose lengthy prison sentences on them. And they have done. So for example, with the Tribunal for Sierra Leone, Charles Taylor, former president of Liberia, was found guilty of committing war crimes and crimes against humanity during the Sierra Leone Civil War because he was backing one of the sides in that civil war. And he was convicted and sentenced to 50 years in prison. He was the first ever head of state to be convicted of war crimes by an international court of any sort. The International Criminal Tribunal for Rwanda wound up in 2015, its proceedings. Rwanda, if you didn't know, there was it's often reported as a genocide in 1994 in Rwanda, where about 800,000 people were massacred, mostly ethnic Tutsis massacred by ethnic Hutus. So this tribunal was set up to prosecute those involved in the massacres. 55 convictions were made, including Jean Kambanda, who was the prime minister at the time of the genocide, and he was convicted of genocide, of planning and facilitating acts of genocide. He was convicted of that in 1998, making him the first, at that time, because that was before the conviction of Charles Taylor, making him the first head of government to be convicted for war crimes. Now, so obviously in terms of, okay, how does this help to uphold human rights? The idea is that this ends the idea of impunity. Impunity is when you can commit crimes and get away with them. And up to this point, there'd been a feeling that, heads of government and leading government officials are never really held to account for their crimes. So these tribunals changed that. And they sent a strong message to leaders all around the world. Look, do not expect to have impunity for your crimes. You may be the president, you may be the prime minister, but one day you may well have to answer for your crimes, and you may well be punished for them. So the idea of this, by preventing this impunity, this acts as a deterrent against future atrocities, because leaders now or in the future will see those convictions and think, I better think twice before I get involved in massacres, because I don't want to be hauled up before one of these tribunals one day. So in terms of upholding human rights, the theory of these courts, these tribunals, is that they act as a deterrent to other leaders, to show them that they can't be guaranteed impunity for their crimes. Beyond that, of course, it's a simple matter of justice. If people have committed the crimes, they should be punished and have been punished, which is another positive, arguably. But there have been criticisms made of these tribunals. And one problem for them is that, of course, the tribunals themselves don't have their own police force. They're